Thank you, Your Honors. By the way, Ryan is no longer a party.
Oh, well, that's the name of the case still. Go ahead.
Good morning, Your Honors, and may it please the Court. My name is Eve Brockman, appearing on behalf of Ignite International Limited, the defendant and appellant in this case. One of the key issues in this case is whether the good faith exception applies under California Labor Code Section 203 in the absence of any evidence suggesting bad faith on the part of the company. The good faith defense prevents punishment in genuine cases of uncertainty as to whether there was an employment relationship. Sorry, I was just catching my breath for a second. I was running back to the courtroom. Okay, so the question here is, with regard to that defense, is did Ignite have reasonable grounds to believe that appellee, Ms. Pavillard, was an independent contractor, and also was there an actual employment relationship? That's sort of the second issue, but proving that there wasn't an actual employment relationship isn't necessary for the good faith defense. Here we have a model who was hired for a single-day photo shoot for an ad campaign by a third-party photographer the photographer signed a written contract with
So let me ask you this. So you're up here after a jury verdict and a judgment on a verdict, correct?
Correct, Your Honor.
Okay, so now in order to prevail, you have to convince us that something erroneous happened at that trial that was prejudicial to your defense, correct? To your side, correct?
Absolutely correct, Your Honor.
All right, so we're pretty familiar with the basic facts in the case. So I'd like you to tell me why or where or when the district court erred in its ruling such that your side was prejudiced, and therefore the judgment has to be set aside and either reversed outright or sent back for a new trial.
Yes, Your Honor.
And maybe you could start by telling me what was the theory of your defense. What was the defense at trial? So,
Your Honor, we are appealing the court's denial of our Rule 50 motion. So we tried to bring it before the jury trial. The court said we could bring it later in writing. We did bring it later in writing. The court applied the willfulness test of the Dynamax case, the ABC factors, which this court already determined in Hill v. Walmart is not the test. And in fact, Your Honor, Justice Pius, you wrote the case that we cite for the standard of review, and that would be the Harper case. Mm-hmm. And you said, we review de novo the district court's denial of a renewed motion for judgment as a matter of law. And at the same time, though, the court is required when doing that review to take all of the evidence at its face value. You don't weigh the evidence, and you review all of the evidence that was provided at trial. However, even if you applied a substantial evidence standard of review in this case, there was no evidence of bad faith on the part of the employer. And there were some really important facts that weigh in favor of the good faith defense, which I'd like to get to. But just to answer your question, it is de novo review, but the facts that were presented in the case are important and must be reviewed by.
So your argument, so before us, your argument is that the district court just erred in failing to grant your Rule 50B motion.
Correct, Your Honor. That's what we're appealing, is the denial of the Rule 50 motion.
Okay.
And the other thing is...
So you don't claim that the district court made any error in the jury instructions?
Well, actually, yes. So jury instructions...
Well, you just told me that you're appealing the Rule 50B.
I think the jury instructions are telling so the jury did make a finding of willfulness. Uh-huh. But willfulness does not require a finding of bad faith.
Did you request that the district court instruct the jury about the good faith dispute defense?
I don't know, because it's not in the record, and I was not the lawyer who handled it.
Well, that suggests then that they didn't, right. Correct?
That was my thought, too. It was never asked of the district court to instruct on good faith or bad faith.
And that's why we're appealing the Rule 50 ruling. And even if so the wrong standard was applied across the board. The bad faith defense was never truly considered or not properly considered by the trial court. In its ruling on the Rule 50 motion, the trial court did mention the good faith test in footnote 2 of its ruling, but if you read that, it's not really applying the standard correctly, because it really does require, so what the good faith standard is a good faith dispute that any wages are due, and that occurs when an employer presents a defense based in law or fact, which, if successful, would preclude any recovery on the part of the employee. And the fact that a defense is ultimately unsuccessful does not mean that the good faith defense does not apply. And defenses presented which under all circumstances are unsupported by any evidence are unreasonable, or are presented in bad faith will preclude a finding of a good faith dispute, but that's not the case here. There's no evidence of any bad faith, and in fact, what you have, we're not even sure. And just getting, I mean, it doesn't seem that this is a case where there was any employment relationship formed in the first place, but you understand I'm saying we don't have to prove that in order to get to the good faith defense. But you've got a contractor who hires his friend.
You got a jury verdict.
We did.
Yeah,
Yes, Your Honor, but no reasonable jury could find it.
Well, that's the problem. There's a jury. You want to go back to the facts, and that you want to go back to your version of the facts, and that's just not the way it works after there's been a jury trial, and you're not really challenging the jury instructions or the way in which, I mean, the whole, as I understand from reading parts of the transcript and parts of the record, is that your theory was, there was no good faith, and there was no bad faith, and as a matter of law, we're entitled to a verdict we're entitled to judgment in our favor.
Well, even getting away from the facts, Your Honor, as a matter of law, there was no contractual privity between Ignite and Ms. Pavillard. There was contractual privity between Mr. Ryan and Ms. Pavillard. If you look at Trial Exhibit 15, yes, Your Honor.
That question was put to the jury, though. The jury listened to all the evidence that you had and that she had, and they determined there was an employee relationship.
As a matter of law, Your Honor, judgment should have been entered in favor of Ignite because, for a couple of reasons. First of all, there was no contractual privity between Ignite and Ms. Pavillard. No reasonable jury could have determined that there was any contractual privity between them because there's a written contract between Ignite and between Mr. Ryan and Ms. Pavillard. Mm-hmm. And Ms. Pavillard was retained for the photo shoot at Mr. Ryan's request. So based just on that issue.
But the jury heard that she was informed that, what's the name of, Ignite, that Ignite was looking to hire a model for $100,000 a year who would, participate in periodic shoots during the year.
There was no dispute at trial that she was not hired for that position.
Right, but the jury heard all of that. It was just, as Judge Collins just said, the jury heard all of that evidence and determined that there was an employment relationship. But there's a basic presumption in California law that when you retain somebody to do work, you're presumed to be an employee unless you can show otherwise. And here, I guess your argument was this was just a one-day shoot. It was hired by Ryan, and, that's it. We weren't her employer. But the jury heard that and said no.
We're not challenging the jury verdict. We're challenging the denial of the Rule 50 motion. And so the way that, based on Harper, the way that the court is required to analyze it, is a de novo question. And the court reviews all of the evidence that was presented in the underlying proceedings. So what I'm telling you, what I'm arguing, is that even if you get away from that standard and you look at whether any substantial evidence or whether any jury could reasonably find that there was an employment relationship, the answer is no. When you look at the Borrello factors, by the way, the trial court didn't have the benefit of the Walmart case in this trial because Walmart was decided April 26, 2022, and then this case went to trial before that opinion was available. And if it had, perhaps it would have applied the Borrello factors. Also, counsel in the trial court didn't have the benefit of Walmart. So they believed that Dynamex was the correct standard, and perhaps that's why there was no challenge to the jury instructions that did not include a requirement for finding of bad faith. So the jury was never instructed that they had to find bad faith in order to make a willfulness determination under Section 13520 of the.
Did you ask?
I asked that earlier,
Did
whether
you
you asked, and you said you didn't know. It suggests that it wasn't asked.
Right, but everyone, the court and counsel, believed that the correct standard at the time was the Dynamex case and the ABC standard, which doesn't require finding of bad faith. And subsequently, very shortly after, this court determined that actually the Borrello factors are the standard, and that the good faith test doesn't require, the good faith defense doesn't require a showing of bad faith.
So you're saying
Right,
the
excuse
law,
me, I said that wrong. It does require a showing of bad faith.
the law changed a week later, or whatever it was, a couple weeks later, is what you're saying. Walmart came out a couple of weeks later after the trial.
After the trial, Your Honor.
So shouldn't we look at the law that was in place at the time of the trial?
I think what Walmart was doing was providing guidance to the district courts about the law that should be applied. It wasn't changing the law. So the law was still, and this court found in Walmart that clearly the Borrello factors were the factors that should be applied in the district courts. We understand that the court is fully aware of the facts, but I think if we just take a concise look at the timeline, the undisputed facts at trial, which under the Harper standard, this court is supposed to review all of the evidence presented at trial. And we're just talking, even if we just look at Ms. Pavillard's testimony, right, undisputed facts. She had been a professional model since 2015 when she was a senior in high school. She was represented by a well-known modeling agency. She was retained by Mr. Ryan. Mr. Ryan signed the contract on her behalf. There was written contractual privity between Mr. Ryan and she. She didn't demand payment for at least 4 months until after 4 months after the photo shoot, which was October 5th, 2018.
Your
Yes, Your Honor.
client paid her.
They paid the modeling
Had to do
agency.
with Mr. Ryan,
Our client paid the modeling agency,
not
Be-
Mr. Ryan.
not Mr. Ryan. Mr. Ryan never paid the modeling agency as he was required to do under the contract. My client paid the modeling agency. The modeling agency took its percentage and then gave it to Ms. Pavillard. The fact that my client paid the modeling agency very shortly after it actually became aware, which was much later than the 4-month mark when she asked Mr. Ryan for payment. She asked Mr. Ryan to pay her. My client was surprised when it found out that the model hadn't been paid. And within just, they had a call a few weeks later, they paid the modeling agency. I think that's reasonable conduct on the part of a company that doesn't want a model going around saying that she didn't get paid for a photo shoot she did for the company. And so frankly, the record doesn't even indicate, as I said, any contractual privity, let alone an employment relationship. And we would submit that the Rule 50 ruling on the merits should be reversed, whether you apply the de novo standard or you determine whether a reasonable jury could have found an employment relationship based on the evidence and the facts. And that brings us to the appeal actually from the fee award. We've combined those two appeals. And so even if the merits appeal is not granted, the fee award should be reversed. Now, we're getting into some complicated California labor code law and some gray area, and I will say, I believe it might be an issue of first impression. But what we are saying is that the sole cause of action in this case was under Section 203 for the penalties, waiting time penalties. And we contend that penalties are not wages. If you look at the definition of wages under Labor Code 200, Section 200, it defines wages as all amounts for labor performed by employees of every description. So wages are payment for labor performed by employees. They are not penalties. And the court cited Kempf, the sole case that the trial court cited on behalf of Kempf in support of its opinion, in support of its ruling on the attorney fees, was Kempf. And that is an unpublished Ninth Circuit case, so it's non-citable in this court. And also, it's inapplicable because there was actually a Section 201 claim brought in Kempf. Here, there was no Section 201 cause of action. It was purely on Section 203, penalties, not wages. The closest case that we think that the court would look at for this would be the Kirby case. Kirby found that Section 203 penalties cannot be awarded for simply failure to provide meal and rest breaks. Naranjo later came after that and said, if there is a failure to pay the overtime for the meal and rest breaks, that failure to pay the overtime is a failure to pay wages, and so Section 203 could apply. But at Naranjo's page 112, it makes the distinction between itself and Kirby, and doesn't reverse Kirby in any way. So if you kind of look at that sort of line of thinking, there is a distinction between an award of unpaid wages, which there was no cause of action for that here, no Section 201 cause of action, and other kinds of awards or other kinds of damages under the Labor Code. And here we think that, additionally, if you step back, penalties on attorney fees on top of penalties is like a double penalty. Here, the plaintiff was awarded $90,000 in waiting time penalties after disappearing for 4 months before ever asking to be paid. And now, on top of it, was awarded $350,000 in attorney fees for unpaid wages. In conclusion, this is exactly the case where waiting time penalties do not and should not apply, and there's no bad actor to punish in this case. So the good faith defense, even if it wasn't successful at trial under the Rule 50 motion, should, as a matter of law, provide a complete defense for the company, for Ignite, with regard to the waiting time penalties. And with that, I will reserve the rest of our time for rebuttal, please.
Quick question. Are you conceding that the jury verdict should stand, but we should set aside the waiting time penalty? Is that what you're saying?
I'm sorry, didn't quite understand.
Are you conceding that the jury verdict should stand, but that we should set aside the waiting time penalty?
Your Honor, we're arguing that the waiting time penalties should be set aside and that the jury's that no reasonable jury could determine that that there was an employment relationship.
Won't give half a loaf.
That's what we contend, Your Honor.
Thank you.
Okay, thank
Great.
you.
We'll give you 3 minutes when you come back up for rebuttal.
Thank
Come
you.
on up. Thank you.
Good morning, Your Honors. May it please the Court, my name is Jordana Thigpen, and I represent the plaintiff in this action, Kaylee Ray Pavillard. I was the trial attorney for this case as well, Your Honors, and I obtained a jury verdict in the court on behalf of my client, who was not paid for 595 days. And if there was ever a case which clearly evinces the remedial purpose of the statute at issue, Labor Code Section 203, I would submit, Your Honors, that this case is up in the top 5. Maybe it's not the best case of all time, but it is up there. This statute, Labor Code 203, has been a part of California law for a long time. The wage statutes in California they exist to prevent wage theft. That's the reason for them. Starting in the 19th century, people were oppressed by employers taking advantage and hiring them for single-day work, not paying them. People would have to go back again and again to try to obtain their pay. And unfortunately, as this case demonstrates, not much has changed in particular industries, despite a growing body of law which clearly states that people who are hired, even on a temporary basis, need to be paid when they are discharged.
When you went to trial, what did you have to prove to prevail? You meet your prima facie case.
Yes.
Because you were only after the penalties at this point. She had been paid.
Correct. And if you look at the citations to KC 2704, which is the KC instruction for waiting time penalties, in that citation, or rather in that list of citations, which are publicly available, as noted in Oppenheimer versus Sunkist Growers, that's 153 Calap 2nd Sup 897, 1957, a tender of the wages due at the time of the discharge, if properly made and in the proper amount, terminates the further accumulation of penalty, but it does not preclude the employee from recovering the penalty already accrued. So the fact that she eventually was able to obtain her...
So you had to prove that there was an employment relationship,
That was step one,
step one.
yes. And then
And
also...
that she didn't get paid.
that she did not get paid, and further, as according to the KC 2704, that it was willful. And what willful does not mean a bad, malicious intention. It simply means intentionally or intentionally failed or refused to perform the act in question,
Yeah.
here providing the pay.
So it was a pretty short trial, and after you finished your presentation, their counsel, Ignite's counsel, stood up and said, I want to make a motion.
Correct.
It wasn't clear exactly. The district court didn't quite seem to catch what kind of motion he wanted to make, but he eventually made, I guess the jury was sent out, and he was eventually allowed to make his motion, which turned out to be a 50A, correct?
Correct, Your Honor.
And then the judge said, well, wait a minute. Let's just reserve that until later.
Yes, and he was given full opportunity to brief the issue. I provided my own opposition to that. The argument is essentially, well, we're saying that we thought, we got it wrong, right?
Hold on just one second.
Yes, Your Honor.
All right. So what was then the theory of the defense?
The theory of the defense was merely that, they had good faith, that they are entitled to the protection of this 6 Cal Code Reg, Section 13520, 8 Cal Code Reg, because they simply thought that they misclassified her. But this, you can't just intone a magic defense and therefore it applies to your case. You have to support it. It was an affirmative defense that they acted in good faith. So the trial court was sitting there the whole time. Judge Klausner was there. He listened to the same evidence. Where was any evidence of any good faith on the part of Ignite? Ignite strategically decided not to put on any of its own witnesses, any employees, maybe someone working in the HR department, maybe Mr. Bilzerian himself. There was nobody there, a PMK, nothing. So that was objectively unreasonable to make a defense that is not supported by any evidence. It is simply unreasonable. Now,
Okay, so let me ask you this. Were there any instructions on the good faith defense?
no, Your Honor, there was not any instructions on the good faith defense. And this...
Did they ask for any?
I just reviewed it. It's the record that was filed by the
You were
appellant
there,
was extremely. Right? I was there. The record is light. I'll say kindly on the appellant's record in this case.
Well, let me ask you this: did they propose any jury instructions?
I just looked in. This is why I hesitate to say because it's not part of the record. But I just looked, and the joint jury instructions that I have in my own records do not show any good faith. They were jointly proposed. Mm-hmm. They were jointly discussed and negotiated and met and conferred as required by the local rules of the Central District. And then Judge Klausner made very minor edits. I'll note about the difference between Borrello and ABC. The ABC test is subsumed within the Borrello factors. Right. Both parties, and I did so as a belt and suspenders approach in this case, knowing that there might be some question down the road or some attack down the road if I'm able to secure this verdict for my client. I put in all the evidence possible to address each of the Borrello factors. So, first of all, the instructional error claim is not before Your Honors. It was never brought as a point in the briefing. And that's a problem for appellate review. And they cannot claim instructional error because they had joint jury instructions. And I have a footnote in my brief about that at page...
So let me ask you this. Under California law, is the determination of whether something is, whether they have a good faith defense, in the cases that I read in preparing for today's argument, seems to suggest pretty clearly that it's a question of fact for the jury. Is that correct?
You know, Your Honor, this is the problem with this defense. I will refrain from stating my policy arguments about this defense or my feelings about how it is worded for purposes of providing notice to courts. As I noted in my brief, some courts have interpreted it very liberally on behalf of the employers. I would say, I would dare to say too liberally, in my opinion. But that being said, this defense is a question of fact, unless it's a question of law. So it can be a question of law in some cases. In others, it is a question of fact, and this case presents that. I would note that a lot of the cases where there has been a good faith defense applied, for example, Amaral versus Cintas, there you had a brand new living wage ordinance, and there was a question of whether that applied to the workers in question. You know, okay, maybe that's fine. Then you have Barnhill, the origin, right, of the good faith defense, the reason we have it. That case early on, in the early, I believe it was mid to early 80s, I could look up the exact year Barnhill was passed. That case was whether you could deduct a loan from an employee's final paycheck. And there was a split in the courts of appeal. Coming in and saying, well, we made a mistake. We thought someone was supposed to be classified this way, and, you know, it turns out, hey, we got it wrong. Okay, merely intoning that, that's not a good faith defense. That is not objectively reasonable. The fact that you are caught, the analogy is you're driving down the road, you thought the speed limit was 65, it's really 55. It's not going to work. It's the same concept, and it's unacceptable that it has been extended in this manner to be basically a get-out-of-jail-free card in some courts that are still kind of misconstruing that. I'll also note on that point, a lot of these cases, they just don't go to trial on this issue. A lot of cases that come up on 203 penalties, they come up in the context of a class case or a PAGA or a summary judgment. So you're really not getting this in-depth analysis of where the court, you know, how it's to be applied. What do you look at? There's no jury instruction on that. KC 2704 states willfully. It then cites from cases willfully simply means intentionally failed or refused, and that's it.
Okay.
Yes.
In the record, is there any evidence of bad faith on behalf of the defendant?
Oh, yes, Your Honor. There is extensive evidence of bad faith, and I'm glad you asked about that, because the bad faith here is they knew that she was not paid, and they continued to deprive her of her pay.
Did they know she was an employee?
The fact that I don't know, Your Honor, because there's no evidence from them on that point. All there is her testimony. The record supports her finding. The jury has established with its verdict, right? The jury found that there's an employment relationship. There's no evidence in this record, for example, that, and this is I've taken from cases, so this is what other courts have noted as being something that a reasonable employer would do or that would create a good faith dispute. For example, what did they do to classify employees when they hire them? What kind of procedure did they have? Did they look at the labor code, at the DLSE forms that are online, for example, and the checklist to determine, wow, is this an employee or is this an independent contractor? What am I doing? Did they establish that they had reviewed any of the relevant case laws, such as Smith versus Superior Court, which involved a hair model that appeared at a trade show for a one day, and there was held to be able to accept penalties? There's nothing like that in this record that shows what they did, and it was their affirmative defense, and that is the law,
So
and they established no evidence.
You're saying they should have presented it as an affirmative defense.
It
and
is.
Therefore, have the judge instruct on that particular defense. Because when I look at the Hill versus Walmart case, it says a good faith mistake about a worker's employment status is a defense to waiting time penalties. And that's whether you're successful with the defense or not.
But, Your Honor, it has to meet one of the standards, or rather, let me say it this way: if any of these points are met. So, for example, if it acted in bad faith, if it acted in bad faith by not paying her when at some point the money was due, when it knew. It says it didn't know and that she secreted herself, which is not true, and the record does not support that. She did try to reach out. She had testimony at her trial that she looked around at the end of the shoot to get paid and looked for Ignite personnel. They had all fled the building and there was no one there to pay her, and that is in the record. So the fact is she could not, there was no one that said, oh, I thought you were an employee, or rather, I thought you were an independent contractor, so, let me go away, and then, you can fight it out with me later, right? Nothing, she couldn't have any conversation with them. She went to go get paid, and they weren't there. Then she attempted to reach out to Mr. Ryan, the photographer, and that's all the contact that she had. She didn't have the email or the contact information for these individuals. So she reached out to him. He, in turn, reached out to the company. It turned out that the people who worked there at the time had been terminated by the company. So his emails were going to basically a vacant chair. Then, finally, they find out. By May 2019, there's direct communication with Mr. Bilzerian, the company's principal, in which Mr. Bilzerian says, how do models just not get paid? Well, it's because you don't pay them. That's how they don't get paid. So there is extensive evidence of bad faith.
What do you believe Walmart means? I noticed you happen to be counsel of record in Walmart, so why don't you tell me what you think it means?
I was the appellate counsel, yes. I argued the appeal for that case. It was a very different record than this case. This case involves a full jury trial, whereas Walmart came to Your Honors another panel, on a summary judgment. And again, that's where most of these good faith cases come from. I think that I attempted in my brief to use the formula that's set forth in Hill. In other words, that if a defense is objectively unreasonable or is unsupported by any evidence or is made in bad faith, we have all of those factors here. And Walmart did not, Hill versus Walmart did not state, well, you always get away with it. Because think about the consequences of that. Here's the jury verdict, successful. We go through a trial. The person has not been paid in 595 days, or put aside that it's one plaintiff here, it could be a class of people. It proves that they can obtain the penalties. And then a judge can simply overturn it based on an atonement of a defense with no evidence that's objectively unreasonable on these facts and that's made in bad faith. It's simply not the law, and it's not the public policy of California. So I think that the Walmart defense and this case are actually, they coexist. The Walmart defense doesn't change anything about this case. From my perspective, I think that this case is showing why we, in fact, need to have a broadly construed remedial statute for making sure that workers are paid on time.
Can I ask you another question?
Yes, Your Honor.
Could you respond to the attorney's fees issue?
Yes, I will. I would like to do that. The attorney's fees in this case, the defense relied extensively on some case law that was abrogated. So not only at the trial court level, Naranjo, the Supreme Court Naranjo, came out the day that Ignite's opposition to the fee motion was due. So Ignite could be forgiven for not checking Westlaw that day, although it did cite the appellate version, the Court of Appeal version of Naranjo in its brief. But, presumably the brief could have been done. So they received supplemental briefing to address the Supreme Court version of Naranjo. There's nothing inconsistent, or rather, there's nothing inconsistent in Naranjo with the position that appellee here, my client, has. Naranjo, yes, it is dicta, I agree, if we're going to be formal about statements that are made in opinions. It was not directly addressing a Labor Code 201 to 204 claim, which this case is. This case was brought for non-payment of wages. We do not have to have a Labor Code 201 claim, but nonetheless, it is pled in the complaint that this action is founded upon and brought on account of a Labor Code 201 claim for non-payment of wages when they were due. And that entitles us, under the clear language of Labor Code 218.5, to attorney's fees. And there's an excellent discussion in Naranjo, particularly the pages of 111 to 112. Those are the points in the Naranjo opinion that discuss the logical analysis of why these penalties under 203, they are such that they are based on non-payment of wages, they are brought on account of, and therefore they're covered under 218.5. Most of the case law that was cited by the appellee in this case dealt with specifically other statutes, Labor Code 226, 1194, these other statutes that are different, and there's been an evolving body kind of parallel to the Labor Code 201 and 204 body of law. In that other area, eventually the Supreme Court came around in Naranjo and said, no, the penalties are still wages for purposes of obtaining attorney fees. Why? Because it's so important to have this remedial protection, to have the ability of employees to facilitate them obtaining what they're entitled to and obtaining payment on time when they work for it. That's the most important policy, one of them in California that we have, is that people are paid on time for their work. And not doing so, it's a form of theft. And it puts the charge, you see, onto the society when people are not paid on time. And that is unacceptable in a modern society, or any society, frankly. Now, there's another element of
This, what's the strongest case that supports your position?
on the attorney's fees, Your Honor. I would say it is Naranjo, because it's the most recent Supreme Court opinion. The dicta that I'm referring to is specifically found. I hate to characterize it as dicta, Your Honor, I really do, but it was referred to that, and technically, it was not a Labor Code 201 to 204 case. So I will say that, and I understand that. But the language is found specifically at 112, page 112 of the Naranjo opinion. I do think that case is. It is an indication of what the California Supreme Court would do when considering.
If they got the issue, if they had the issue in front of them, that's probably right.
This is a roadmap, Your Honor, of how they'd interpret it. Because, again, they want to construe these protections broadly for California workers, and that is to everyone's benefit.
Okay.
Yes. Thank you, Your Honor.
Thank you very much.
Thank you.
You have 3 minutes for a rebuttal. Thank you.
Thank you, Your Honors. First, I want to address the question that Justice Paez asked about whether there's any evidence of bad faith. And the only response that was given was that she wasn't paid. And she asked to be paid and wasn't paid. The reality is she was paid. She was paid within weeks of Ignite actually finding out that she hadn't been paid. And if you look at the trial transcript, she asks to be paid for the first time in February of 2019, 4 months after the photo shoot, and she asks Mr. Ryan. The very first time that Mr. Ryan or anyone tells anyone at Ignite about the issue with non-payment was April 24th, 2020. And that's at trial transcript 48, lines 3 to 5. And that's when Mr. Ryan messages Mr. Bilzerian. And Mr. Bilzerian expresses surprise. How in the world do models just not get paid, as she stated? And so we see that this is the first time in 2020 that they're finding out. And literally, so then Mr. Bilzerian reaches out to the plaintiff, to Ms. Pavillard, and she doesn't respond.
Yes, this. You made, earlier on, you made reference to some sort of written agreement?
Yes, Your Honor.
Was that agreement admitted into evidence?
Yes, that's Trial Exhibit 15, Your Honor.
Okay.
Would you like me to check the ER?
No.
Okay. And
I can check.
And that is, so again, distinguishing this case from Walmart, not distinguishing it, but it's even more appropriate for the good faith defense, because in Walmart, there was a contract between Walmart and the model's agency. Here, Trial Exhibit 15 is a contract between the model and the photographer. So I think that's an important distinction. Additionally, in Walmart, it was 10 photo shoots over 15 days. Here, it was a one-day photo shoot. And in Walmart, the photo shoots occurred in the store, whereas here, the photo shoots occurred at the photographer's studio. There was some mention about how no Ignite personnel that they had fled, literally that they had fled the building. The evidence is that she didn't ask anyone after the photo shoot from Ignite because they weren't there. They weren't running the photo shoot. They did show up for a few hours. Mr. Bilzerian was in some of the photos, but they...
Goats?
With goats, yes. But they didn't, they weren't running the photo shoot. It was Mr. Ryan who was tasked with doing that. So I also wanted to just briefly address, again, she said she wasn't paid for 595 days. Well, we can see what the timeline was. She didn't ask for payment, and the company didn't find out she hadn't been paid until the very end of that time. So with that, Your Honors, we would simply ask that the court reverse the denial of the Rule 50 motion and enter judgment in favor of Ignite, or at the very least remand with instructions to apply the standard that this court expressed in Walmart, and also, of course, reverse the fee of appeal for the reasons that we gave. Thank you very much.
Thank you very much, and we thank both counsel for their arguments this morning. This case is now submitted, and court is adjourned. Thank you.
All rise. This court for this session stands adjourned.